This episode was produced by Bach Pro Se. Run your own legal research at prose.trybach.com.
So imagine you're sitting at your kitchen table and, it's late at night. The house is completely quiet.
Right.
And sitting right there in front of you is this massive, thick stack of paper. The legal document, but it's not a contract for a car or like a mortgage for a house.
It's way heavier than that.
Exactly. This document dictates exactly how you're going to raise your child. I mean, it spells out when you are allowed to see them, the exact physical location you have to stand when you hand them over to your ex-partner, and who gets to make the final call if your kid needs braces or therapy or, needs to change schools.
Yeah, you're looking at a Florida parenting plan.
Right. And it dictates your daily reality and your child's reality, basically until they turn 18. It is, without a doubt, one of the most emotionally charged documents a person can ever sign.
It really is. I mean, it's basically the physical manifestation of a family restructuring itself. People naturally pour all their anxiety, their guilt, their lingering anger, and their hopes for the future into this one stack of paper.
Which is totally understandable.
Oh, absolutely. But the thing is, the moment you step into a courtroom, all of that raw emotional chaos, it has to be translated into strict mechanical legal order. The judge isn't looking at your emotional journey, They are looking at a structural framework.
Okay, let's unpack this.
Yeah.
Because that translation process, moving from that emotional chaos to this rigid legal structure, that is our entire mission today.
Yeah, we've got a lot to get through.
We do. In this deep dive, we are decoding the highly specific legal architecture of Florida parenting plans. And we're going to put a sharp focus on how things operate specifically in Broward County and the 17th Judicial Circuit. We are cutting through all that emotional noise to look at the pure legal mechanics of how courts actually decide your family's future.
And we are pulling from a very precise set of sources for this. We're looking really deeply at Florida Statute section 61.14, which, if you don't know, serves as the absolute bedrock of child custody law in the state.
The ultimate rule book.
Exactly. We're also analyzing local procedural guidelines for Broward County, along with some major appellate and Supreme Court decisions, including a highly impactful 2026 ruling, Baz v. Edwards.
Oh, man. That case.
Right. It perfectly illustrates the severe consequences of playing games with these legal rules.
So before a judge in Broward County even begins to weigh what is in the quote-unquote best interest of your child, a parenting plan actually has to structurally exist.
Yeah.
I was looking at the standardized Florida Supreme Court form 12.995A in our research.
Standard form, yeah.
Yeah, and it's essentially a massive checklist. It forces parents to map out everything because the law requires absolute minimums just to get through the courtroom doors.
Right. Because under Florida Statute, section 61.13, specifically subsection 2B, every single parenting plan must contain 5 mandatory elements, no exceptions.
It's the bare minimum.
Exactly. The law basically demands the who, what, when, where, and how of your child's entire life.
So rather than just, reading a boring list, let's look at how this plays out in reality. The statute requires you to outline how you'll share daily tasks, create a specific time-sharing schedule, and designate who handles health and school decisions.
Which all sounds standard, but
it goes down to a level of detail that I think really surprises people. Like, you have to specify the exact technologies used for communication and the precise physical locations for exchanging the child. You can't just write, we'll text each other and swap the kids when it makes sense.
No, absolutely not. A Broward County judge will throw that right out. And what's fascinating here is that the court isn't trying to micromanage your life just for the sake of bureaucracy.
Right. It feels bureaucratic, but it's not.
Exactly. This is entirely about conflict prevention and enforceability. Imagine a vague plan that just says, exchanges will happen at a mutually agreed place.
Which sounds nice and cooperative on paper.
Right, until they actually have to do it. If the parents are in a high-conflict situation, every single Friday afternoon turns into this high-stakes negotiation. One parent wants to meet at a gas station halfway, the other insists on meeting at the child's school.
And suddenly, the Friday swap becomes a total battleground.
Yes, and the child is caught right in the middle of it every single week.
I look at those 5 mandatory elements like the blueprint of a house. If you submit a blueprint to the city permitting office and it's completely missing the plumbing system, they don't care how beautiful the living room looks on paper. They just stamp it rejected.
That's a great way to put it.
Right. If you submit a plan in the 17th Judicial Circuit and leave out the communication methods, the judge will reject it. They demand precision because vague plans just lead straight back to endless, incredibly expensive litigation.
The court knows that ambiguity breeds contempt. By forcing warring parents to immediately confront the physical, logistical realities of co-parenting, like literally defining that FaceTime calls happen at 7 p.m. on Tuesdays, or that exchanges happen at the local police station lobby, the court builds a firewall against future fights.
So, okay, we have a structurally sound blueprint. We've forced the parents to agree on the physical logistics to stop the Friday afternoon standoffs. But once you have those walls up, how does the judge decide what actually fills the rooms?
That's where things get complicated.
Right, because if the parents absolutely cannot agree on the time-sharing schedule, how does the judge actually make that call?
Well, they turn to the 20 statutory factors found in Section 61.13, specifically subsection 3. These 20 factors act as the lens through which the court determines the best interests of the child.
And this is an exhaustive list, right?
Yeah, very. A judge will look at the child's home and school record, the developmental needs of the child, the moral fitness of the parents, evidence of domestic violence or substance abuse, even the geographic viability of the parenting plan.
Okay, wait, I'm confused here. Because as of 2023, Florida law established a presumption that equal 50-50 time-sharing is automatically in the child's best interests.
Yes, that was a massive shift in the law.
Right. So if the law says 50-50 is the default starting line, why do we even need those 20 best interest factors anymore? Doesn't the new law just override them and tell judges to split the time evenly and move on?
No, not at all. And honestly, that is a highly dangerous assumption for any parent to make. It completely misunderstands how a rebuttable presumption works mechanically.
Okay, break that down for us. What does rebuttable presumption actually mean in practice?
A rebuttable presumption just sets the default starting position. The court walks into the room assuming a 50-50 split is best. But a parent can overcome or rebut that assumption by proving, by a preponderance of the evidence, that equal time sharing would actually harm the child.
Okay, let's define preponderance of the evidence for a second, because that sounds like some heavy legal jargon.
Sure. Think of the classic blindfolded lady justice holding a scale. The scale starts dead even at 50-50.
Right.
Preponderance of the evidence simply means you have to put just enough weight on one side so it dips to 51%.
Oh, so it's not like beyond a reasonable doubt in a criminal trial. It's just slightly more than half.
Exactly. It is the legal standard for proving that something is more likely than not. And those 20 statutory factors we just talked about, those are the exact weights you use to tip that scale.
I see.
If you can show that the other parent's work schedule makes a 50-50 split geographically impossible, or, there are severe substance abuse issues, you use those specific factors to rebut the 50-50 presumption.
So the factors are the actual tools you use to prove the 50-50 starting line shouldn't apply to your specific family.
Precisely. And even if a judge does evaluate everything and decides to order a 50-50 schedule, they still have to follow strict procedural rules. Which brings us to a critical warning from the appellate courts covering Broward County, specifically a case called Marquez v. Lopez.
Oh, this case is wild to me. In Marquez v. Lopez, the trial court ordered equal time sharing, which perfectly aligns with the current 50-50 presumption.
Right, it sounds like an open and shut case.
Yeah. It seems like the judge did exactly what the 2023 law asked. But the appellate court completely reversed the decision. Why?
Because the trial judge failed to show their math.
Show their math.
Yes. In Florida, a judge cannot simply hand down a schedule, even if it's the default 50-50 split. The law requires the judge to make a specific finding either spoken out loud on the record or written explicitly in the final judgment that the arrangement is actually in the child's best interests based on those 20 factors.
Wow. It's like a complex algebra test in high school. You can write down the correct final answer at the bottom of the page, but if you don't show the step-by-step work of how you got there, the teacher fails you.
That is the perfect analogy. Appellate courts demand the math because it prevents arbitrary rulings.
That makes sense.
If a judge just says 50-50, next case, there is no way for the higher court to know if they actually considered the child's developmental needs or, say, a history of domestic violence.
Right. They need to know the judge actually looked at the specifics.
Exactly. If you walk out of a Broward courtroom with a favorable schedule, but your judge didn't put that specific best interest finding on the record, your victory is incredibly fragile. It is one of the most commonly reversible errors in family law.
Okay, so the schedule dictates the geography, right? Where the child sleeps on Tuesdays, who gets Thanksgiving this year. But geography is just one piece of the puzzle.
It's a big piece, but definitely not the whole picture.
Right. What happens on a random Tuesday morning when the child needs a major medical procedure, or one parent wants to move them from public school to a private academy, and the parents fundamentally disagree? how does the court divide the actual power of making life choices?
That concept is called parental responsibility, and Florida law recognizes three main structures for this. The default is shared parental responsibility. This means both parents retain full rights, and they are legally required to confer with each other and jointly make major decisions affecting the child's welfare.
So they are basically forced to agree, which sounds great in theory until they don't.
Yeah, exactly. On the extreme opposite end of the spectrum is sole parental responsibility.
Which I assume is pretty rare.
Exceptionally rare. It means one parent makes all the decisions alone without even consulting the other. A court will usually only order this if shared responsibility would be actively detrimental to the child, for instance, in cases of severe documented abuse.
But let's look at the messy middle ground. What if they share responsibility? They are both fit parents, but they just constantly hit a brick wall. Every single medical decision, every school choice, it just turns into a stalemate.
That is where the third option comes in, which is shared parental responsibility with ultimate decision-making authority.
That sounds like a mouthful. How does it work?
It's essentially a hybrid. Both parents still have to discuss the issue. They still have to try to reach an agreement. But if they reach a total impasse, the court grants one specific parent the final say, the ultimate authority to break the tie.
Now, here's where it gets really interesting. You can't just give someone a blank check to break every tie in the child's life. We looked at case law from the appellate courts, specifically Clark v. Stoft and McClure v. Beck.
Yes, those are crucial cases for understanding the limits here.
So in the Clark case, the parenting plan gave the mother ultimate decision-making authority over areas, quote, including but not limited to education and health. It sounds like a standard legal boilerplate, right? Including but not limited to.
You see that phrase in almost every other type of contract.
Exactly. But the appellate court absolutely struck it down. Why did the court hate that phrase so much in this context?
Well, if we connect this to the bigger picture of shared responsibility, the law allows you to give a tie-breaking vote over very specific concrete aspects of the child's life. In McClure v. Beck, the court made it really clear that you have to delineate exactly what those aspects are.
So you have to be specific.
Highly specific. By throwing in the phrase, including but not limited to, the trial court in the Clark case accidentally made the authority infinite.
It basically turns ultimate authority into a disguise for sole parental responsibility.
Yes, exactly. Think about the mechanics of it. If a parent can break a tie on literally anything they creatively argue falls under that, including but not limited to umbrella, the other parent is entirely stripped of their rights.
Because everything could technically fall under that umbrella.
Right. So the appellate court ruled that judges must rigidly identify the borders. You can have ultimate authority over non-emergency medical care or solely over private school enrollment. You cannot have blanket authority.
I can completely understand why self-represented litigants people filing pro se in Broward County fall into this trap. They are trying to future-proof their lives.
Oh, it happens all the time.
Right. A parent thinks, I have no idea what my ex and I will disagree about 5 years from now when the kid is in high school. So I'll just write, including but not limited to, so I have all my bases covered.
It's a natural instinct.
But what they don't realize is that in Florida law, precision is protection. Broad, sweeping language invites an abuse of power, which goes entirely against the best interest standard.
Exactly. The courts require you to name the exact battlegrounds. You cannot ask for a blank check.
Okay, so we have the blueprint built, we have the schedule assigned, we have delineated the decision-making power with absolute precision.
Huh?
Let's pivot a bit to human nature.
This is where things get really messy.
Yeah. What happens when the ink is dry, the judge's gavel has banged, but one parent is just incredibly bitter? What happens when one parent actively tries to sabotage the child's relationship with the other?
You are hitting on arguably the most heavily scrutinized dynamic in family law. We have to go back to those 20 best interest factors in the statute. The very first one on the list, Factor A, is commonly referred to by family lawyers as the facilitation factor.
Okay, so Factor A focuses on the capacity to facilitate a relationship.
Yes. The statute requires the court to evaluate the demonstrated capacity and disposition of each parent to facilitate and encourage a close and continuing parent-child relationship. They also have to honor the time-sharing schedule and, be reasonable when changes are required.
But isn't it just human nature to be uncooperative during a brutal breakup? Where does a judge in the 17th Judicial Circuit draw the line between a parent just being difficult, like taking 3 hours to return a text message, and a parent legally violating that facilitation factor?
The court draws a very sharp line between emotional friction and actionable legal interference. A judge expects ex-partners to give each other the cold shoulder. They expect awkward exchanges.
Right. They know they aren't best friends.
Exactly. But the court views the child's relationship with the other parent as a protected legal right. When a parent weaponizes the child or creates a systemic physical or emotional barrier to the other parent, the hammer comes down.
Which brings us to the Florida Supreme Court case, CNVIGC.
Yes. This is a landmark example of a severe Factor A violation. In this case, a mother made false child abuse allegations against the father.
Wow.
After a full investigation, the trial court found the allegations were completely fabricated and determined she was actively trying to alienate the child. As a direct consequence, the court drastically reduced her time sharing.
And she appealed the decision, right, claiming the court was legally obligated to give her a roadmap to get her time back.
Yeah, she argued the court was required to outline concrete steps she could take to regain her lost custody, but the Florida Supreme Court firmly ruled against her.
What did they say?
They held that when a parent's deliberate inability to facilitate the relationship harms the child, the court can modify the plan and reduce that parent's time without owing them a step-by-step instruction manual for how to win it back.
Fabricating abuse is the nuclear option, and the court treats it like radioactive fallout.
It really does.
But it's not just extreme cases like false allegations that trigger these consequences. Let's look at the very recent case from July 2026. Baez v. Edwards.
This case is a stark warning about honoring the schedule. In Baez, a mother was held in contempt for withholding time sharing over the Christmas break. She essentially decided she didn't want to follow the holiday schedule that year.
I can imagine so many people in that situation thinking, it's just one holiday, I'll get yelled at, maybe pay a fine, but it's worth it to have Christmas. What was the actual mechanical consequence of her withholding the child?
The consequence was life-altering. The court didn't just slap her wrist with a fine. They found her in contempt, reevaluated the facilitation factor, and modified the entire parenting plan to give the father majority time sharing.
Wait, really? Just for Christmas?
Just for Christmas. She lost primary custody simply for interfering with a Christmas break. The courts do not view withholding a child as an annoyance. They view it as legal self-sabotage.
That is massive, and it perfectly highlights the fatal mistakes people make when they try to navigate this system alone. Our sources noted that pro se litigants in Broward County often use generic, free templates they find online. They fill them out with vague terms like reasonable time sharing or liberal contact.
Which brings us full circle to the 5 mandatory elements. Reasonable time sharing is a legal fiction. It means absolutely nothing to a judge.
Because it's completely subjective.
Exactly. If you don't define exactly what time is yours, if you don't specify that you have the child from December 23rd at 9 a.m. to December 26th at 6:00 p.m., the court cannot enforce it when the other parent decides to withhold Christmas.
So what does this all mean for you? If you are navigating a divorce or a paternity case, you have to realize a hard truth. While your situation feels intensely personal, deeply emotional, and totally unique to the judge sitting in Broward County, it is a strict mechanical process.
It's a formula.
It's a process of 5 mandatory blueprint elements, 20 statutory best interest factors, and highly precise legal language. If you walk in asking for a fair schedule, but leave out the exact exchange locations, your plan is rejected.
Right.
If you ask for ultimate authority over all major decisions, you will be reversed on appeal. Precision is not just legal jargon in family law. Precision is the armor protecting your relationship with your child.
I want to leave you with a thought regarding how the system is evolving. Florida law explicitly states that none of the 20 best interest factors are given a numerical weight.
So they aren't ranked.
No. It is entirely up to the judge's discretion to balance them based on the evidence presented in the room, which means the best interest of the child is essentially a subjective puzzle solved through objective evidence.
A subjective puzzle solved through objective evidence. I like that.
Consider how rapidly our society is changing right now. As our culture shifts regarding remote work from home schedules, the deep integration of digital communication in children's daily lives, and an evolving awareness around mental health. How might the unspoken weights that judges assign to those 20 factors be shifting right beneath our feet?
That's a huge question.
The text of the law hasn't changed, but the cultural lens through which a judge views a stable home environment or proper communication is absolutely evolving every single day.
That is a fascinating thought to leave on. The blueprint remains the same. The 5 structural elements are mandatory, and the text of the 20 factors is written in stone. But the way the judge walks through that house, the way they value the rooms, that shifts with the culture. Make sure your blueprint is flawless so you don't get locked out of the house entirely.
This episode was produced by Bach Pro Se. Run your own legal research at prose.trybach.com.